You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed. You may. Okay. Both sides ready to proceed. Okay, let's return to jury. Okay, state recognizes the presence of jury.
Yes, sir.
And the defense. Members of the jury, did you heed all of my previous admonitions during the noontime and lunch hour? Okay, Mr. Ashton, you may continue.
Thank you. Good afternoon, Dr. Galia.
Good afternoon.
Let's start off by getting through a few housekeeping matters. I want to approach. Let me show you some items that are marked for identification. First is State's Exhibit KL. You recognize that by your office's label as a bag that should contain the laundry bag that was found in evidence in this case.
Yes.
This time you take remove into evidence State's Exhibit KL.
What says your defense? It will be received in evidence as states numbered.
Let me show you what's been marked in evidence, State's Exhibit for Identification KU, and ask you if you recognize that by markings as the bag that should contain the baby blanket photograph we saw earlier.
Yes.
This time, Your Honor, the State would move into evidence State's Exhibit KU for identification.
It will be received in evidence as states numbered.
Next would be State's Exhibit KM. You recognize this as, by the markings of your office, as the container that should contain the body bag with the vegetation that was brought with the evidence.
Yes, I do.
This time, Your Honor, move into evidence State's Exhibit KM for identification.
It will be received in evidence as states numbered.
Show you State's Exhibit KK for identification. Do you recognize that by the markings as the bag that should contain the tied black plastic bag that was brought in with the remains?
Yes, I do.
This time, Your Honor, State would move into evidence State's Exhibit KK.
It will be received as states numbered.
Show you State's Exhibit KO for identification. Do you recognize that by the markings as the bag that should contain the untied plastic bag which found with the remains?
Yes.
This time, Your Honor, State will move into evidence State's Exhibit KO.
It will be received in evidence as states numbered.
Let me show you what's been marked. State's Exhibit for identification KR, and ask you by the markings, that's the bag that should contain the shorts that we looked at in the photograph.
The shorts. I didn't see the shorts in the photograph, I don't believe, but
Those
those are
were
the
in
shorts.
photographs. Let me stop. Did you review photographs of items that were taken and examined by Dr. Cox?
No, I examined those.
Those. Okay, and they should be in here.
Yes.
Okay, thank you. State will move to evidence State's Exhibit KR.
Be received in evidence as states numbered.
Let me show you State's Exhibit KT and ask you if by the markings that should be the bag containing the clothing, the letters, and the stitching.
Yes,
And those are things that were brought in with the body. Is that correct?
that is correct.
State will move into evidence, State's Exhibit KT.
What says the defense? It will be received in evidence as states numbered.
Now let me show you State's Exhibit KS. If I may approach counsel for just a moment.
Right.
I believe by agreement of counsel, rather than have the doctor open this bag to see her markings, that it is agreed that this is the hair knot that was taken into evidence.
That's correct, Your Honor. I have no objection to reading it.
Okay. It'll be received as states number.
Right. That's all it is. All right. Dr. Nellett, we've got the housekeeping out of the way. When we broke, we were discussing the concepts of cause and manner of death, and I believe you were explaining to the jury what manner of death means. Could you explain that, please?
The manner of death.
Manner of death.
The manner is the classification of death based on all of the information that is available to us, both scientific information, both scene information, both historic information, anything that will help us classify that death as to accident, natural, homicide, suicide, or undetermined.
And in assessing all that thing, the medical evidence, the scientific evidence, and the scene evidence, do you bring to bear your experience in forensic pathology?
Absolutely.
In this particular case, based upon everything that you have seen, the photographs, the skeleton itself, do you have an opinion as to the manner of death in this case?
Yes.
What is that opinion?
Homicide.
What do you base that on?
It's based on three main items. First, we know from observational studies, from experience, that it is a red flag that when a child is not reported immediately to authorities, either with an injury, that's something we look for foul play. This child, from history, was not reported for a long time. The other thing that makes it a homicide is that the body was hidden. A child's body is thrown out, hidden in a field. We know that is one of the things we look for when we are looking for a homicide. Also, it's often found that these bodies are in, not always, but closed containers, a suitcase or a plastic bag like this child was. That, again, is from our experience from observational systematic studies, a red flag for homicide. And the last, besides the delay, besides the being found in a field decomposed, would be the duct tape somewhere located on the lower half of this face. There is no child that should have duct tape on its face when it dies. There is no reason to put duct tape on the face after they die. Based on our experience, we've seen that in cases of homicide.
Now, how does the concept of cause of death differ from the concept of manner of death?
Well, the cause of death is the injury or the disease that initiates the chain of events that ultimately results in the child dying or the person dying. So the cause is the specific injury or disease that ultimately causes the death.
In this case, based on the skeletal condition of the remains, can you render a medical conclusion on the cause of death.
The cause of death, what I put was homicide of undetermined means. I believe we can reliably say it's a homicide, but I don't know the means for which that homicide occurred.
Were there any objects found with the body that would have been capable of causing death?
Well, the only possible objects with the body, although I don't know if they cause death, and I'm not even speculating whether they cause death, would be duct tape. If that duct tape was over the mouth and nose, that's a possibility. Suffocation with a plastic bag would have been the only other thing I would have seen there.
Right. You are aware, are you not, of the evidence of chloroform being found during certain portions of the investigation of this case?
I was made aware of that, yes.
Could a child exposed to a sufficient amount of chloroform die as a result?
Absolutely.
But at this point, based upon the medical evidence, can you tell what caused her death?
No, I believe we have enough evidence, and I believe it's scientifically defensible to say it's a homicide, but I do not believe we have enough scientific information to say the means of how that homicide occurred.
Now, are there certain things that you can exclude? In other words, was there any trauma to the body that would
Well,
connote...
the trauma is their body is very decomposed. All I have is bone. So unless that trauma hurt the bones, I can't say. There's certainly, I've had other cases where there's been blunt trauma to the abdomen, and I can't say from the skeleton. So I can't rule out really any trauma, because sometimes even a gunshot wound would go through, and not touch the bone. So it's very difficult when the body is that decomposed to say why they died.
Now, in this case, was there any injury to the bones that would indicate trauma involving the bone?
There is no ante-mortem injury to the bones that would indicate the cause of death.
And were you made aware of any illnesses that the child suffered that could have caused death, anything of that
I
sort?
specifically asked for any history of illness or problems with this child, and I was told there were none.
No further questions. Thank you, Doctor.
Cross-examination.
How you doing?
Hello.
You okay?
I'm okay.
All right. Now, Dr. Galia, you live in the Orlando area. Don't tell me where, but in the Orlando area.
Yes, in the area.
Okay. And for the period of time of about 4 months prior to these remains being found, you were aware of all of the media attention surrounding this case, weren't you?
I was aware that this was a big case. I do not watch the news, and I listen to NPR, so I don't think I was as aware as most people.
Certainly, if you were wise enough to not necessarily rely on the news, you were aware that there was, in fact, a circus-like atmosphere around the Anthony home. Yes?
I don't know that.
Oh. Well, you knew it was, a lot of speculation and a lot of news about this case for months. Yes?
I did know that there was a lot of speculation about this case.
And you knew that if, unfortunately, remains were found of this child, that your office would be most likely involved.
No, I was hoping it was Lake County.
You were hoping it was Lake County, push it off to the west. Okay.
Different jurisdiction.
Or so anywhere other than the 9th.
That's what I would have liked.
But in fact, you were called and you came back from wherever other business you were on to handle this case.
That's true.
And amongst the various things that you had known prior was news or references, as Mr. Ashton just referred to, regarding the potential of chloroform being involved in this case.
I was told that by investigations at the time we got the body.
you weren't told that the chloroform related to decomposition, but just that there was chloroform involved.
That there was a question of chloroform.
So you then reasoned that perhaps chloroform may have been used, in fact, to contribute to the cause of death of this child.
I think that would be one of the possibilities that we would have to examine.
So one of the things that you did in order to examine that possibility was to bring in an expert. Yes?
I brought in a toxicologist that I knew had dealt with toxicology of bones, which is,
Tough.
not a common thing.
And that toxicologist was a PhD, Dr. Bruce Goldberger from the University of Florida.
It was.
And you sent to him a piece of bone that had been resected from the humerus, was it?
The femur.
Pardon?
The left femur.
Left femur. We had a picture of it a while ago.
No, that was the tibia taken for the DNA. The
Well,
picture I saw.
Which part was sent to Dr. Goldberger so he could test for the presence of chloroform?
The piece of the left femur.
And as a toxicologist, the specific request was to look for chloroform and other what you call volatile chemicals. Is that right?
That is correct.
Meaning you were looking for chloroform and some form of poison.
Volatiles would have been alcohol, isopropanol.
Any kind of chemical that might have contributed to the cause of this child's death.
Yes.
And Dr. Goldberger, pursuant to your directions, submitted these samples to a myriad of toxicological examination tests, didn't he?
Not really a myriad. He only did checked for volatiles and several other tests. It was very limited what he can do with bone. But
Whatever tests were available that could be done were done.
he tried.
And when they were done, the results were negative as to each and every one.
That is correct.
Now, in connection with this whole process, were you present when Dr. Werner Spitz came as a defense expert to want to observe the process?
Objection. May we approach?
You may continue.
I may not be exactly verbatim, but I asked you if Dr. Werner Spitz came down to observe or participate in the autopsy.
Did he? No.
No? Were you aware of him coming down to want to watch your work?
Hearsay. Question, Counsel.
Overruled.
I was informed by my office manager that Mr. Jose Baez had requested.
Objection, Your Honor. I don't believe that's what the court indicated counsel could ask.
He's already allowed me to ask the question.
Well-
He's just answering it.
Overruled. Go ahead and finish asking the question, Doctor.
Go ahead, Nancy.
Go ahead.
I was informed by my office manager there was a request by Jose Baez to bring an outside person in to watch the autopsy, and our policy in the autopsy is that we have a statutory duty to come up with the cause and manner of death. We would preserve everything possible then and make that available to him when we are finished.
Okay. And you told Mr. Ashton that in your determination of the manner of death, you consider all kinds of circumstances.
Yes, I do.
And in doing that, in this case, are you aware of whether or not Dr. Spitz, in fact, did a second autopsy?
Objection, hearsay.
It's a statement.
Okay. Now, I want to go back just briefly to Dr. Goldberger I've been reminded that he's a medical doctor, isn't he?
No, he's not.
He's not?
Dr. Goldberger? He's a PhD.
Is he also a medical doctor?
Not to my knowledge.
All right. Well, what things do you know that he tested besides that piece of bone?
Let's see. For volatiles, he tested bone, the scrapings I took from the inside of the bone, the hair and soil that kind of fell out of the hair. And that was for volatiles. And then he tested the bone, and then the scrapings from the bone marrow, and washings we did from the cranial cavity. And he tested that for by gas chromatograph for prescription drugs, illicit drugs. And then he tested specifically for alprazolam in the bone, the scrapings of the bone cavity, the washings of the cranial cavity were all then specifically tested for alprazolam.
And alprazolam, what's a more common name?
It's a benzodiazepam, also known as Xanax.
Xanax.
Yes,
So he tested for all those things, and all the results were negative.
that is correct.
And speaking of the cranial wash you did not cut open the cranium, did you?
No, absolutely not.
Now, you told Mr. Ashton also that there was no trauma found in your examination, correct?
No antemortem trauma, meaning prior to death. We found some postmortem trauma from animals chewing on bones. And
You found the postmortem trauma. The anthropologist confirmed to you that there was indication of animal activity, right?
oh, you could say that.
Okay.
That was part of my examination.
But anything that happened before, there's no evidence of any form of trauma before when this child was alive.
On the bones, there was no evidence of trauma.
And in your exploring all the world of circumstances about this, you didn't find about any trauma either, did you?
No, I did not.
So if I understand your testimony, you, the long and short of it is, are confirming that despite the investigations, the toxicology, the anthropologists, all of these things, there is no scientific or medical evidence to establish the cause of this child's death. Is that correct?
The means of the homicide could not be determined.
And you determined to call it a homicide as opposed to an accident or indeterminate.
The circumstances of death and did not fit anything but a homicide.
The circumstances.
Yes, the way the body was found,
Okay.
not
I know
reporting
that.
the body.
And also what Detective Melich told you.
I'm not. What part did Dr. Melich tell me? The part that the body wasn't reported for 31 days was what
You
he told me.
learned these things from Yuri Melich, an investigator.
That's our standard
some of the
course
things-
of business.
Some of the things you learned from the media.
From you?
Media
Oh, media. No, nothing from media would have been entered into my decision.
didn't enter your mind.
Well, I can't take anything that the media would say into a decision as grave as this.
So the bottom line is when you say and you place the label homicide, the indeterminate means you're saying that circumstantial evidence to you says that it probably was a homicide.
Not probably. I think that is the only logical conclusion based scientifically on some of the scientific information we have, based on observational information we have about homicides and children dying.
What is the scientific information, the circumstance?
Well, we know, and of course, systematic observational studies are part of science. That's a big part of forensic. It's a big part of how we know our world. We look at all the accidental drownings, for instance, in my jurisdiction. We systematically went through those. 100% EMS is called immediately when the child is found.
Well, that has nothing to do with this case, does it, Doctor?
Oh, no.
Objection, argumentative.
Sustain.
Okay.
Go ahead, Doctor.
It absolutely has something to do with this case. Every death I investigate has to put into the circumstances of death. You can never, ever determine a manner of death, except in very rare instances, just on examining the body. And so it always has to. So we need to know how usually deaths occur. So we have to know, and there's scientific studies in peer-reviewed literature about some of the red flags for homicide.
Objection to the bolstering. She's now talking about studies. We don't have them.
Overruled.
So by my experience and by what is known about the way homicides occur, I felt that the preponderance of evidence and that there was no other logical conclusion could be found by not reporting a child for 30, who has a legal, moral, and ethical obligation to care for a child, not reporting that child missing. The fact that it's tossed in a field to rot in bags is a clear indication that the body was trying to be hidden. Those are, even it being put in a bag is a very big red flag for homicide, and never seen in an accidental death of a child. And the fact that there's duct tape anywhere attached to that child's face is, to me, indication of a homicide.
Okay, now let's back up. What about your circumstantial observations and deductions are scientific, ma'am?
The fact that we know 100% of the time that accidental deaths are reported unless there is a good reason not to be. We know that there is no reason not to report. In fact, if you do not report an injury to authorities, you are risking that child's life. So we know that's partly behavioral science, and we know in all of the cases that come through our morgue that accidents are 100%, particularly on children, are reported unless there is a good reason not to.
So you're trying to tell this jury 100% that there's no way that this death could have been accidental?
No, I said 100% of the time, let's say on a systematic review of drownings, it's one of the more common accidents, 100% of the time when the person finds the child, they call 911 because there is a chance that that child might live. They need to report that and give them a chance.
And what if a person finds an obviously drowned body that's so obviously deceased? What then? Is there some scientific thing to your conclusion about their morality?
No, but I'm looking at the behavior as a systematic observational information that shows that no matter how stiff that body is, they always call 911 on the hopes that that child could be saved. I'm looking at observational data on that kind of death. That's what we use.
So you're saying then, by your determination, the circumstantial evidence is that's what causes you to conclude it must have been a homicide because you can't explain it any other way.
I explained to you the red flags that we know in forensics
First of all, Doctor,
based on behavioral science.
You need to answer my question.
I don't understand.
Your Honor?
Just a second, folks. Mr. Ashton, objection.
Objection to counsel instructing the witness.
I'd ask the court to instruct her to answer my question. The question I asked her called for a yes or no answer.
Please repeat the question.
Objection. Sustained, Mr. Basin. The question did not call for a yes or no answer. It was sort of open-ended. So if you want a yes or no answer.
I'm sorry, I didn't hear the last part.
Okay. All right. Doctor, did you finish answering the question?
I don't even know what the question was.
See?
Okay. Then let's have a new question.
I don't even remember. The bottom line is Let's just take it and make it simple. Cause of death, you don't know. Manner of death, you say, based on the circumstantial evidence, you conclude that it was a homicide for the reasons you told us.
I felt that the manner of death, although the cause of death is homicide by undetermined means, I felt the means were unable to be substantiated scientifically. I felt the manner of death was defensible scientifically based on systematic observational studies.
Okay. Of observational studies of other things, other cases.
Of homicide, how homicides occur, how accidents occur, how natural deaths occur, yes.
Other cases.
Other cases.
Okay. Now, by the way, if these remains had been found 4 or 5 months before, would you have had better chance at scientific evidence?
Absolutely.
And incidentally, you said something about duct tape. Isn't it true from what you observed and saw, if there was any duct tape, it was only in the vicinity of the lower mandible?
That's correct.
I have just a minute, Your Honor.
You may. Any redirect? You may proceed.
Doctor, Mr. Mason asked you about your knowledge of the defense's desire to do a second autopsy of the body.
Yes.
Did you attempt to keep the body in exactly the same condition it was when you received it?
Yes, we did, except for what we had to take for a DNA and for the possible toxicologic testing.
You left the roots in the bones just as you found them?
Yes.
And
in fact, we packaged it nicely so they could keep the anatomic groups together.
And you left the skull intact just as you had found it?
Yes, that's normal procedure for an anthropologic exam, is to keep that intact.
Now, the absence of positive results for chloroform or other substances, does that, as a matter medically, exclude the acute use of those substances at or near the time of death?
Right. We would not expect to find any of those things positive in a bones. That was a long shot trying to check for those, but I thought we would be amiss not to at least try. We would not expect any of those to be positive in a set of bones, even if they were positive at the time of death, even if it was present.
Taking for the purposes of my question, for the following hypothetical, the following facts. Assume that Kaylee Anthony died and was discarded on or about June 16th of 2008, approximately 6 months before the body was found.
Yes.
At the stage that Mr. Mason was asking you about 4 months earlier, which would have been August, so the body's been out for 2 months. What would be the body's condition after 2 months?
Oh, well, it's probably be skeletonized. Certainly would be skeletonized by then.
So if the body had been found in, August, would you expect that it would have been skeletonized with very little soft tissue?
Yes, I would expect it to be skeletonized.
Would you expect the internal organs to be completely
gone?
Thank you. No further questions.
Recross as to those issues. Okay, doctor, you may be excused. State may call his next witness.
Dr. Michael Warren.
solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Could you please tell us your name?
Michael Warren, Warren.
And how are you presently employed?
I am Associate Professor of the University of Florida and Director of the C.A. Pound Human Identification Laboratory.
Can you explain to the jury what the C.A. Pound Human Identification Laboratory is?
The Pound Lab is named after the gentleman who endowed the laboratory. It is a working forensic anthropology laboratory. We are responsible for consulting with medical examiners in cases in which the decedent has become skeletonized, burned, fragmented, or otherwise unrecognizable.
And how long have you been the director of that laboratory?
About 2.5 years.
Kind of give us, if you would, your educational and work history leading up to your becoming the director of the Pound Human Identification Laboratory.
Okay, I had a prior career as a paramedic for 15 years. I returned back to graduate school in 1991, received my master's and PhDs at the University of Florida, training under William Ross Maples, forensic anthropologist. I did 1 year postdoc after I received my doctorate in the Pound Lab and was a visiting professor until I was hired onto the faculty in August of 2000 as an assistant professor.
And did you work as an assistant professor at the University of Florida until you became an associate professor and then took over as the head of the laboratory?
That's correct. Since the year 2000 up until I became director, which would have been in January 1st, 2009, I was working in and out of the laboratory, consulting on cases, but also doing teaching and research in the Department of Anthropology.
Have you ever been qualified as an expert to give opinions in the area of forensic anthropology?
I have.
And on how many occasions, if you can approximate?
Probably 16 or 18 times.
And in what type of jurisdictions? Just in the state of Florida, other states, federal?
There's been 2 other states, Alabama and New York, but mostly Florida.
This time, Your Honor, I would submit Dr. Warren as an expert in the area of forensic anthropology.
No objections.
Ladies and gentlemen, the juror, Dr. Warren, will be accepted as an expert witness in the area of forensic anthropology.
Now, do you have I don't know if you call it a specialization or a special interest in forensic anthropology involving children?
My doctoral research was in fetal growth and development, the effect of pathology on linear bones of children, but that was during the fetal period. Any other interest I've had has been involved in determination of age at the time of death, both in juveniles and adults.
Now, did you become involved in the investigation of the death of Kaylee Marie Anthony?
I did.
How did you first become involved in this investigation?
I was contacted by Dr. Galia and Dr. John Schultz on December the 15th in 2008 to come down and assist in the analysis of the remains.
And did you travel to the District 9 Medical Examiner's office for that purpose?
Yes, sir.
Now, in addition to examining the remains, did you also examine photographs taken of the remains as they appeared when they were found?
Yes.
I want to direct your attention to one specific area of that. Do you recall, either from the photographs or what you were told, that what the position of the mandible was in reference to the skull when it was first found?
Yes.
Go ahead.
Yes.
All right. What was that position?
The mandible was still articulated at the glenoid fossa or mandibular fossa of the cranium. The mandibular fossa at the TMJ, the jaw joint.
So you say articulated. What does that mean?
It means it was still in place. It was in situ.
If you could slow it down just a little bit.
I'll do
it would
that.
be of great assistance to us.
Okay.
Yes. Thank you. Why is that noteworthy?
Well, that particular joint is a regular type of synovial joint with an articular disc. It's a very lax joint in that joint allows movement of the jaw in 2 different directions, both as a hinge and also to move anteriorly. There's nothing to hold that jaw in place once the soft tissues decompose. So on surface depositions, on cases in which remains are found on the surface of the ground, it would be very rare to find the jaw still articulated with the rest of the skull.
And in your experience, in cases that you have worked over the length of your career, have you ever had a case in which the jaw, in an above-ground deposition, was still in that position in the skull.
Yes.
And what were the circumstances of that case?
These are cases that I worked when I was doing some human rights work in the Balkans, in Bosnia, and I think also probably in Kosovo, in which the decedents had tape over their face.
Other than that circumstance, do you consistently find that the mandible has disarticulated from the skull?
Yes.
And is that your experience, or is that experience? Withdraw the question. Now, you're familiar with the photographs of the position of the tape in reference to the mandible and the opening for the nose, the nasal aperture. Is that correct?
The photographs, yes, sir.
Now, can you tell from the photographs whether the tape in life would have been over the nose and the mouth?
No.
Why is that?
The tape had moved.
Now, did you attempt to determine whether it was possible that a single piece of duct tape of the type on the body would have been sufficient to cover both the nose and the mouth, even just one piece?
I did.
Overruled.
What efforts did you make to determine whether a single piece would have been sufficient to cover both the nose and the mouth?
Two methods. I consulted the literature, the scientific studies that have been done on growing children to try to figure out the distances, the normal distances between various landmarks on a child's face. The best piece of literature I was able to find involved
proper bolstering.
I believe he's referencing the research he used in order to render his conclusion, not the conclusions of other.
Well, Sustain, just tell us what you did, Doctor.
All right.
Okay.
Without telling us what the literature
I'll
said.
rephrase.
Okay.
Did you research the literature to determine estimate ranges of the distance between the tip of the nose and let me rephrase. Which anatomical features were you interested in for this purpose?
I was interested in the nasal aperture, the very bottom of the nose, and on the skull that's called the nasospinale. So it's a point that we use when we do measurements. So it's basically the very root of the nasal aperture. And I'm also interested in the bottom of the teeth and oral airway.
Right. And were you able to get estimates based upon Kaylee's age of what that might have been?
Estimates, not using those exact landmarks, but in particular one landmark that is from the middle of the eye down to the bottom of the chin.
All right. Now, what was the other method that you used?
I used a method called video superimposition.
And explain to the jury what, pardon me, what has video superimposition been used for in forensic anthropology normally?
It's primarily used to exclude the possibility that the remains in question are those of a particular decedent.
How do you do that if that's your purpose?
You would take the skull that you have of an unknown decedent that is in the laboratory, and you would take a photograph or a video of that skull, and you would take a photograph of the person, the putative decedent, the person that law enforcement or the medical examiner thinks that person may be.
Repeat the last word. I didn't understand it either.
I'm sorry.
Putative.
Excuse me?
Your last word that began with a P.
Putative.
Putative. I'm
Putative.
sorry, putative. The suspected decedent.
Go ahead.
If you slow it down, Doctor, it would be very helpful.
Okay, I'm sorry. So you take the skull at that point. You also take the photograph of that individual, and using a comparison method where you are able to superimpose that image on top of the skull using anatomical landmarks, you may be able to make a statement on whether or not it's possible that the photograph is of the person that is the unknown skull that you have.
What type of things are you comparing? You said anatomical landmarks, like what?
You usually would use something like the bottom of the teeth. We also use what we call osteometric points. So there are various points on the skull that we use when we do our metric analyses. So when we measure with calipers, we use certain anatomical landmarks. So it may be the edge of the orbits. It may be what we call, there's a point at the root of the nose that we use, the top of the head and the contours of the skull.
Now, in this case, identification of the skull was not the issue that you were addressing, correct?
Correct.
How did you utilize that process in seeking information as to whether the tape could have covered the nose and mouth?
I used that technique in order to scale the photograph of the skull with a photograph that was provided me by the FBI of the tape. Both of those images had metric scales in them, so by superimposing one image on the other and making those scales the same size, we're able to know that those two images are, in terms of scaling, correct.
So that would help you put the tape over the skull, but how do you then determine how it would have been had the face been there?
Well, we would go back to the original techniques that we've normally used superimposition for. That is to take the photograph of the skull, the photograph of the decedent, and then scale those using those anatomical landmarks.
So you're, in essence, making the photograph of the live person the same size as the one-to-one with the photo of the tape.
Correct.
Using the skull as the vehicle to do that.
Exactly.
And in this case, were you able to do that?
I was.
And did you review earlier State's Exhibit QH marked for identification? We showed it earlier here during the
Yes.
break. Okay. And does that fairly and accurately depict the video superposition showing that process?
It does.
And would it help you in explaining what this tells us about the ability of the tape to cover the nose and mouth?
It would.
This time you ought to move it down to State's Exhibit QH, the one file shown to the court, the movie file.
Noting previous objections by the defense, and you renew those at this time, Mr. Baez?
Yes, sir.
It will be received in evidence as states numbered.
Is it queued up?
Okay, prior to publishing this, I need to give you the following instructions, ladies and gentlemen of the jury. This evidence is to be used only to illustrate the expert's opinion. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. You may proceed.
Oh, yes. Okay, it's published to the jury now. Play it. Dr. Warren, in the video we just saw, we see the outline of the tape being moved up and down on the photograph. What is the reason for that?
To show that we don't know where the tape was, that it could have been higher, could have been over both the nose and the mouth, but it could have been lower than that.
So there is a position demonstrated there where the tape would have been only over the mouth and not occluded the nose.
That's correct.
But based upon that video and your own research, would the single piece of tape, if applied in the position shown on the video, been sufficient to have covered the nose and mouth and made breathing impossible.
Yes.
No further questions.
Cross-examination.
May it please the court, Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Dr. Warren.
Good afternoon.
Sir, you were hired in pretty early in this case, were you not?
I wouldn't use the term hired. I was consulted, yes.
Okay. You were consulted fairly early in this case.
Yes.
But you never saw the duct tape while it was attached to the hair mat.
That's true.
And that's what it was attached to, the hair mat.
Yes, there were strands of hair that were adhering.
And the photograph that you used to do this, what is it, a flash movie of sorts?
That's a QuickTime movie from a Photoshop program.
And Photoshop's something that you use to design websites and things like that?
It can be used in a lot of different applications. I'm not sure if you can use it for that.
Okay. However, it doesn't give you precise measurements and things like that. That's something that you did based on your experience.
It should give you very precise measurements if you're scaling. I mean, the image is the image. So,
however, the photograph that you have of Kaylee, you grabbed that from the internet.
correct.
And you don't have a scale on that photograph.
Correct.
And in fact, you don't even know how old Kaylee was when that photograph was taken.
That's correct.
Okay. And, sir, the only reason you've shown this to this jury is because I guess it's to demonstrate that it's possible that this could have occurred.
Correct.
And when we say this could have occurred, I mean it's possible that a piece of duct tape could have covered her mouth and her nose.
Yes.
Okay. And you're not testifying in any way that that's actually what happened.
No, I'm not.
Okay. And when you say it's possible, it's also possible that it was not.
Correct.
In fact, it's a form of speculation, is it not?
It's a form of demonstration to show a possibility, yes.
Which is a form of speculation since you don't know, right?
Right.
Now, sir, you can't testify that this duct tape had anything to do with Kaylee's death, can you, sir?
No.
In fact, you can't even testify or base anything scientific that that tape was associated with Kaylee after her death.
Can you
I'll
ask
rephrase
that
the
again,
question.
please?
Sure. You don't know if that duct tape had anything to do with the disposal or the death.
True.
Okay. And in fact, I'm gonna draw a model here, and I'd like to see if you agree with the facts.
Okay.
You understand that Kaylee was found on the surface, correct?
Correct.
And that below the surface was the hair mat.
Correct.
Above the surface, I meant, sorry.
Yes.
Correct? Okay. Sorry. And then after that was the mandible.
Yes.
And then above that was the skull.
Correct.
Okay. Now, generally speaking, when a person's alive, their hair is on top of their head.
Correct.
So somehow, actually I forgot to mention, the duct tape was also found in front, like that, attached to the hair, correct?
Correct. Across the front.
Okay. These multiple problems aside. everyone see that okay, or want to pull it closer? May I put it closer to the tree? Everyone see that okay? As I mentioned earlier, sir, the hair is generally up here, correct?
So that I can see it too. Sure. Slightly, so that I can.
Is that better?
Yeah.
I don't want to exclude any.
No.
Everyone can see that okay? Okay.
I cannot.
Oh. That might help.
Yeah,
How about
That's good.
May the
Thank
witness
you.
stand down, Your Honor.
The witness may stand down. Sir, when you stand down, you're going to have to face in the direction of the court reporter so she will be able to see and hear you.
Now, sir, as we mentioned, the duct tape was attached to her hair, correct?
That's my understanding from observing the photographs.
Okay. And that's really the only thing. Let me rephrase that. It was your understanding, too, based on consultation and the evidence at the scene, is that at one time her skull was inside of 3 bags, correct?
Objection, hearsay, speculation. Who?
Sustained but rephrase the question.
Yes, sir. Based on the evidence that you were given to make your to form your opinions, it's your understanding that Kaylee Marie Anthony's remains at one time were in 3 bags, correct?
That is my understanding, yes.
And it is the understanding that there is a canvas bag. Were you able to see that canvas bag?
Only photographs.
Okay. And that canvas bag had a shape, like a round cylinder shape, correct? Like that as an opening?
The photographs that I saw were not clear in terms of what the opening looked like.
Okay. Were you able to see the handles of the bag?
I don't recall handles.
Okay. Do you recall if that bag are you able to close that bag?
Again, I've only seen photographs of the bag, so
So you have no idea as to whether the bag was closable or not?
I do not.
Okay. And you have no idea as to whether this tape was used to wrap Kaylee's remains or whether the duct tape was in the anatomical position of which it was found, because, of course, you did not see the remains as they were decomposing.
Objection,
Correct?
compound, argumentative, assumes facts not in evidence.
Sustained, rephrase the question.
Yes, sir. You have no idea the placement of that duct tape.
The duct tape was at least over the mandible and some portion of the maxilla.
Okay, now, but that's because it was attached to the hair, was it not?
I make that statement on the fact that the mandible was found articulated with the skull.
And while we're talking about the skull, there's absolutely no way that the hair would have gotten underneath all of this because the body wouldn't have decomposed in that way. Isn't that true, sir?
Objection assumes facts not in evidence. I could explain more at the bench.
Approach.
Thank you.
Sir, I'm going to show you State's Evidence 218. May I approach the witness?
You may.
No, sir. That's not.
Okay.
Thank you.
Now, that's a photograph where you can clearly see the hair mat, correct?
Correct.
And that hair mat was on the floor in the wooded area off Suburban Drive, correct?
The photograph is not Suburban Drive, and the document speaks for itself. The photograph speaks for itself.
Your Honor, I would object to these speaking objections.
Overruled. Let's continue.
When the skull was found, the hair mat was on the floor, correct?
On the surface,
Yes, on the surface, of the surface. And right Slightly above it was the mandible, correct?
Based on the photographs that I've seen, I was not at the scene.
I understand. But based on what you know,
Yeah.
okay? So in order for the hair mat to be underneath the skull, it's clearly underneath the skull, is it not?
Yes.
Okay. So in order for the hair mat to be underneath the skull, on the floor, something had to have made it either roll there or put the hair in that position, correct?
Yes.
And the duct tape also made its way in that direction with the hair, did it not?
Toward the surface, you mean?
Correct. Towards
Correct.
the surface. Correct. That's what I meant. Okay. May I get the photograph?
You may.
Thank you.
Now, the video you showed, again, of the possibility that that duct tape could have been in that position was quite graphic, was it not?
It was.
Okay. And was it to try and appeal to the jury's emotions when you asked Mr. Ashton to do that?
Objection. Decisions of what may be approached.
You may. Yes. Members of the jury, would you step out for a minute, please? You may be seated. You may proceed with your proffer.
Yes, sir. Dr. Warren, you testified earlier that it was under your suggestion that this movie be prepared, correct?
Yes.
Okay. And when you had that discussion with Mr. Ashton, was it for the purpose of appealing to the jury?
No.
Was it for the purpose to demonstrate to the jury something of a graphic nature?
No.
Was it for the purpose of getting sympathy or getting the jury angry?
No.
And it was just for the mere possibility of showing that the duct tape could have possibly covered the nose and mouth.
That's correct.
I have no further questions.
Okay. Check and see if the jury's ready to come back in.
I
You
think
may.
we should use a comfort break since we got
All right, why don't y'all take a 5-minute break and we'll get started at 20 minutes past. Okay, you may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to proceed.
Yes, sir.
Okay. All right, let's return to jury. State recognized presence of jury.
Yes, sir.
And does the defense.
Yes, sir, we do.
Mr. Baez, you may continue, sir.
Thank you, Your Honor. Dr. Warren, I just have a couple more questions. You're aware that another piece of Henkel duct tape was found 9 feet away, correct?
I was not aware of that.
Oh, okay. Now, the possibility of this demonstration that you did, that was just, of course, one possibility, correct?
Asked and answered.
Overruled.
One possibility
the demonstration, the quick time video that you did, that was just one possibility. It's demonstrating one possibility, correct?
True.
Okay. And there are other possible scenarios that could be involved with both Kaylee's death, correct?
Correct.
And also the duct tape, correct?
In terms of the position of the duct tape over the face, no.
No, what I'm saying is that there are other possibilities, since you don't know the history of where the duct tape was originally, there are other possibilities that could involve that duct tape.
Of course.
Okay. And you don't have any QuickTime movies of those, do you, sir?
No, sir.
All right, thank you. I have no further questions.
Redirect.
Doctor, do you have an opinion as to whether the duct tape was placed on Kaylee Anthony before decomposition?
Yes.
What is that opinion?
It was placed on prior to decomposition.
What do you base that on?
On the fact that the mandible was found on the position of the mandible still articulated with the rest of the cranium. On a surface deposition, skeletal elements get moved around. They get moved around by scavengers, insects. That mandible will always become disarticulated unless it is held in place by something.
And in this case, can you see anything holding it in place other than the duct tape?
No, sir.
Now, you're not saying the duct tape was actually stuck to the bones.
It was never stuck to the bone, no, sir.
So how does the duct tape during decomposition keep the mandible in place?
The mandible's probably stuck to the soft tissue as well as the hair, and then when the soft tissue decomposes, the duct tape stays in place and supplies some sort of support for the mandible.
Now, Mr. Could we have published States 218, please, Your Honor, in evidence? States Exhibit 218, the photograph.
Okay.
Pull it up and make sure. You need the Now, Doctor, this is the photograph that you were shown by Mr. Bias. I'm going to publish it to the jury now. Is that correct?
Correct.
Now, this photograph shows that the hair, in fact, is not under the mandible, but posterior to the mandible. Is that
Correct. It's under the base of the skull.
not under the mandible?
Correct.
Now, how, during decomposition, does the hair end up not on top of the scalp?
The hair is attached to hair follicles on the galeal or scalp tissue. When that tissue decomposes, it tends to slide down, and so it's not uncommon to find what essentially looks like a bird's nest of hair settled around the base of a skeletal element or skull.
As we see here, around the back of the base of the skull?
Yes.
And is that something you commonly see in decomposition elements where the hair basically just falls back and creates a nest?
Correct.
Just like that?
Yes, hair preserves fairly well. It lasts a while. It preserves fairly well. It lasts a while.
No further questions.
Mr. Bias?
We can leave. We can bring that back on. Yes. Okay. Yes, sir. Thank you.
You want that published, Mr. Bias?
Yes, sir.
218?
218, sir.
Okay, published.
Can you see that, sir?
Yes.
Can the ladies and gentlemen of the jury see it? Yes. Now, there is significant root growth underneath the mandible as well, correct?
I do see some roots there.
Okay. And roots underneath the mandible can also, in conjunction with, well, actually, let me ask you this. You see roots also attached to the hairnet, do you not?
I do.
Okay. The roots could also contribute to keeping the mandible in place, could it not, sir? As it is demonstrated in this photograph.
That's possible.
Okay, we can unpublish. And the statement that you say, well, if I can have just a moment.
Right.
I have no further questions. Thank you.
Okay.
Does active decomposition inhibit plant growth?
No.
Could those roots have grown?
Calls for an opinion outside of this witness's expertise.
This,
Sustain, establish a foundation. So I'm going to answer the question.
I'll just move on to another question, Judge.
Okay.
I guess what I'm going to ask you is, can the roots can't grow in the hair until the hair has already fallen off the skull, correct?
I think sustain unless you establish a foundation as to the base of his knowledge and his qualifications to give an expert
okay.
opinion.
Are you familiar at all with plant growth involving decomposition? Is that something you normally see?
Yes.
Okay. You're not a botanist,
No.
but have you had experience in evaluating plant growth in the context of taphonomy of remains?
Yes, and locating graves and changes in the environment in general.
All right. Now, I guess my question is, Mr. Baez asked you if the roots in the hairball could keep the mandible in place. You said it could, correct?
It's possible. I would say roots can would keep a mandible in place under certain circumstances. I would say that's possible, yes.
But what has to happen before the roots can do that in this case? What would have to happen? Does the hair have to first fall off?
Yes.
Okay. My point is, until that point, there's nothing for the roots to grow in.
Correct.
So the only thing that would be holding the mandible in place is what?
The tape.
Thank you.
Any additional questions?
Two areas that he covered that I'd like to ask you on. Number one, you're not a botanist.
Correct.
And forensic botany is a whole other field, correct?
Correct.
And you would defer to a botanist as to those opinions.
Yes, I would.
Okay. Second of all, you can't, based on the evidence, the limited evidence that you have, know the tracking of that duct tape, can you, sir? Because you don't know where it was originally at to begin with.
The tracking.
Yeah. Where you can't testify as to the positioning of the body at any point in time, can you, sir? Okay. And you can't testify as to where the hair was at one time or another.
No.
And all we have at this point are photographs that you've observed of duct tape stuck to hair.
Correct.
No further questions.
Okay, may the doctor be excused. Thank you, Dr. Warren. You may be excused, sir. State may call in next witness.
Solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, ma'am.
Michael Vincent, Vincent.
Sir, you've testified in this case prior to today, correct?
Yes, ma'am.
You're a crime scene technician with the Orange County Sheriff.
Yes, ma'am.
In connection with this case, did you recover certain entomology or insect evidence from the trash that was located at one time in the Pontiac Sunfire that you've discussed during prior testimony?
Yes, ma'am, I did.
Your Honor, if I may approach the witness with OO and OP for identification.
You may. Yes, sir.
Let me have you take a look first at OO for identification. Do the records of the Orange County Sheriff's Office or does your memory allow you to recognize that item?
Yes, it does.
And what do you recognize it to be?
This is one small vial containing maggots in a preserved solution.
Was that an item that you collected, sealed, placed into that envelope for ultimate transmission to a Dr. Neil Haskell?
Can I refer to my report real quick?
May the witness utilize his report to reference his recollection as to what he did with the information?
You may.
Okay, this is the vial that contained the maggots, correct? It was in the trash bag.
Right. Did you collect that from the trash bag and send it to Dr. Haskell?
I have in my report that I collected it, but that's not my initials on the envelope.
All right. May I have your scissors?
Right.
Yes, these are the maggots that were collected from the trash.
Do the records of the Orange County Sheriff reflect that you sent that item then to Dr. Neil Haskell for evaluation?
Yes, ma'am.
I'm going to show you what's been marked as OP for identification. Have you take a look at the item inside that packaging and tell me if you recognize it as something that you collected.
Yes, ma'am, it is.
What is it?
This is bug insect eggs called pupae. It's in the late stage of their life cycle.
All right. You collected that item, sealed it, and sent it to Dr. Neil Haskell for evaluation?
Again, it was sealed by Jenny and shipped by me. Yes, that's
Right.
correct.
I'm sorry, sealed by?
It was sealed by Investigator Walsh and shipped off to Dr. Haskell by myself.
You're talking about Jennifer Welch.
Welsh, yes.
Those are all the questions I have at this stage.
Cross-examination.
Mr. Vincent, good afternoon, sir.
Good afternoon, sir.
These items of evidence were taken from the garbage bag, correct?
Yes, sir.
And these were collected from you on July 16th?
What was collected?
These pupae.
No. They were collected on August 28th.
However, you processed the vehicle on the 16th of July, correct?
No, I did not process the vehicle.
Was it July 17th then?
When you're referring to, what do you mean by processing the vehicle?
You inspected the trunk, inspected the items that were found in the trunk,
Yes.
and you're aware of the ability of entomology to be a useful tool for law enforcement, correct?
Yes, sir.
And I just heard you describe to Ms. Train-Burdick that the insect puparia of this item of evidence was in the later stages.
Yes.
Okay. And it's your understanding that an entomologist can look at the stage of where maggot life is and be able to determine the life cycle of that specific maggot, correct?
Your Honor, I'm going to object. This is outside the scope of the witness's expertise. No foundation's been laid for the witness to be able to answer.
I think
His opinion.
I'm sorry. I think the foundation has been laid by this witness's testimony and his knowledge of the collection of such.
Collection and objection sustained.
May I ask him if he has knowledge of that, Judge?
Can you attempt to establish a foundation?
Yes, sir. Sir, you have some training in entomology, do you not?
Yes, sir.
In fact, you went to a course at the University of Florida, did you not?
Yes, sir, I did.
Okay. And this course taught you that there are different stages of a maggot and other insects.
Yes, sir.
Okay. And an entomologist can take these stages and give you a pinpoint even of a time of death, correct?
Yes, it's possible.
Okay. And you were aware of this type of evidence when the car was collected on and inspected by you on July 16th, were you not?
No.
You didn't see any insect activity either in the garbage bag or in the trunk of the car on June 16, 2008? I'm sorry, July 16, 2008.
I didn't, no.
So you didn't see any insect activity in the trunk of that car when you first saw it?
Not in the trunk of the car. There was none that I saw.
All you saw was insect activity in the garbage bag, correct?
Sometime later, correct.
Okay. No further questions, Judge.
Redirect?
No redirect, thank you.
All right. Thank you, Mr. Vincent.
Thank you, sir.
State may call our next witness.
Robin Maynard.
solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, and the whole truth.
I do. This way, please. Robin Maynard, ROBINMAYNARD.
You may proceed.
Thank you. In December of 2008, were you employed as a crime scene investigator with the Orange County Sheriff?
Yes, I was.
Were you one of the individuals who assisted at a site off of Suburban Drive during the recovery of the remains of Kaylee Marie Anthony?
Yes, I was.
As part of the assistance that you gave to other crime scene investigators there, were you responsible for documenting the collection of entomologic or insect activity that was present at the scene in December of 2008?
Yes, I was.
Was that evidence collected over a period of several days?
Yes, it was.
If I may have OX for identification. and for council's reference, that's page 8 of her report.
You may.
I'm going to show you what's been marked as OX for identification. Have you take a look at this packaging and tell me if you recognize it as something you've had contact with in the past.
Yes, I do.
How do you recognize it?
It's my label with my handwriting, and the evidence seals have my initials on them.
What is this item and when was it collected?
It's pupae, and it was collected 12/14/08
Where?
at 8900 block of Suburban Drive.
As you collected each of these items of insect evidence, did you relay that information to other crime scene investigators on Suburban Drive?
As I collected those items, I consulted with Dr. Neil Haskell after, at the time, over a period of days that I collected it. I don't understand what you mean, other crime scene investigators.
Did you document the location of the collection
Yes.
with other investigators?
Yes, I did.
Would you have been the individual who placed it into this package and sealed it and then allowed the later transmission of the evidence to Dr. Haskell?
Correct.
If I may have items PT, PU, PV, PW, PX, PY, PZ, QA, QB, QC, QD, QE, and QF for identification. For council's reference, page 14.
You may.
All right, I'm going to show you these in sequence, starting with PT, PU, PV, PW, X, PY,
John, may I stand up for
Yes,
PZ. I'll go to the Q items in a moment. Can you take a look at each of these items and tell me if that is entomologic evidence that you collected from the scene on Suburban Drive in December of 2008?
Yes, they are.
Were you the individual who would have collected the item of evidence, placed it into the packaging, and sealed it for a later evaluation by Dr. Neil Haskell?
Yes.
Same series of questions for QA through QF. Can you look at those packages and tell me if those are items of entomological evidence that you collected on Suburban Drive in December of 2008?
Yes, they are.
Do each of the items that you've reviewed so far have an indication on the exterior, the location on Suburban Drive where the item was collected?
Yes, it does.
May I have PH through PS for identification? Page 19. Great, I'm going to show you PH, I, J, K, L, and M for identification. Have you take a look at the packaging of each of those items and tell me if those are items of entomological evidence that you collected and packaged from the scene on Suburban.
Yes, it is.
Do you indicate on the exterior of each of those packages where on Suburban that piece of evidence was collected?
Yes.
Would you have been the individual who then sealed it in the package and sent it or consulted with Dr. Neil Haskell about the evaluation of this evidence?
Yes, I was.
Let me show you what's been marked as PN, PO, PP, PQ, PR, and PS for identification. Have you taken a look at each of those packages and tell me if that's entomologic evidence that you collected from Suburban Drive in December of 2008?
Yes, it is.
Do you likewise indicate on the exterior of the packaging the location on Suburban Drive where the item was collected?
Yes, I did.
Once collected, did you then place the item in the packaging and seal it pending further evaluation by Dr. Neil Haskell?
Yes, I did.
If I may approach the witness with what's been marked as KV for identification.
You may.
Thank you. Ma'am, can you take a look at KV for identification and tell me if you recognize the packaging?
I do.
How do you know that it is something that you've had contact with in the past?
It's my label with my handwriting and my initials on the evidence seal.
Do you indicate on the exterior of the package what was placed in that item?
I do.
Okay, what is it?
Piece of cardboard mat with pink raised heart-shaped material attached.
Where was that item collected?
It was on one of the lanes in the remains recovery search. One of the lanes, there were lanes, when you do a search, there's a search area, and I identified things through each lane and how many feet north or south it was to that lane. So this was collected in one of the lanes of the search area.
On Suburban Drive.
On Suburban Drive, yes.
The item was collected by you and placed into this package and sealed?
It was.
Any other questions of this witness, Your Honor? Thank you.
Cross-examination.
Good afternoon, Ms. Maynard.
Good afternoon.
The entomological evidence that you collected, this was under the direction of Dr. Neil Haskell, correct?
Correct.
And there were multiple people doing this operation, were there not?
There were.
And it was thoroughly done.
Yes, it was.
In fact, it was so thoroughly done that Dr. Haskell even told you, stop, I have enough.
That's correct.
Okay. And the item that you just identified with the cardboard, that was found in one of the lanes.
Correct.
And there were all kinds of items found on all of these lanes, correct?
There was multiple evidence that was found in the lanes. Yes.
And when we say evidence, we also are talking about beer bottles,
Correct.
beer cans,
Correct.
some tires.
Yes.
There were also these concrete pavers nearby, correct?
I'm unaware of any concrete pavers. They didn't have anything to do with my area of responsibility.
There were so many items there in that area, it got to the point where you stopped collecting items because there was so much debris in that area, correct?
I was the lead in charge of sifting, so I was not in the actual primary search area. I had set up sifting stations west of the primary search area.
But you were there. From what you saw, there were plenty of items there, correct?
Correct. The items that I had to deal with were items that were being sifted. So if they were bigger, they really weren't a part of my responsibilities at the scene.
It appeared to you, by being there, that people threw things there all the time. It was a common dumping area. There was plenty of debris.
I can't say it was a common dumping area. There were multiple items in that wooded area, correct?
That have nothing to do with this case. That's fine. I'll withdraw the question, Judge. This area is also across the street from an elementary school, correct?
I don't believe it's directly across the street. I believe the elementary school was further to the east.
The actual building is a little further to the east, correct?
Correct.
But it is right next to a elementary school, correct?
It's down the street from the elementary school.
Kids walk to school there?
I didn't see any children walking to school there.
Just a second, ma'am. Do you have personal knowledge whether kids walk to school or not?
No, I do not.
Okay. Objection sustained.
You don't have any personal knowledge as to whether children walk to school?
Objection sustained.
Yes, sir. I have no further questions.
Nothing else, Your Honor.
May the witness be excused.
She may. Thank you.
Thank you, ma'am. You may be excused. Okay, ladies and gentlemen of the jury, the time is now approximately 1 past the hour of 5. We're going to recess for today. We will start back tomorrow morning at 9 a.m. The dessert lady, how was that? Okay. All right. Please remember my previous admonitions. See you in the morning at 9 a.m. Okay, you may be seated. Okay, are there any other matters we need to take up prior to recessing to 9 a.m. tomorrow?
I have a brief one, if I may.
Yes, sir. You may proceed.
Yes, Your Honor. I feel compelled at this time to file, do an order of tennis motion for a mistrial based on the highly prejudicial evidence that was admitted today on the superimposition video of a child's skull with duct tape wrapped around the face and a photograph. This was based on the witness's proffer that this was a possible way of, or a possibility, and the witness also testified that this was speculative. I think the overwhelming prejudicial effect was outweighed by its probative value, and we would hereby move for a mistrial based on that fact, Your Honor.
One question. I'm just waiting for the doors to be shut. Okay. Has not both the state and the defense advanced various theories as to the location of the duct tape?
As to the various locations of the duct tape? Yes.
Okay. And did not the witness testify that that was one possible scenario that he rendered, that there could be other possible scenarios?
The witness did. However, it's our position that it's not outweighed by the video of like 2 minutes, or however long it was, almost 2 minutes long, of seeing a photograph of this beautiful child with duct tape wrapped around her face and her skeleton skull in the background.
Okay.
I think that served only one purpose, was to inflame the jury, especially this witness testified that he could have described and explained and given that opinion without the video.
Now, you indicated that the photograph showed duct tape wrapped around the head. Was duct tape wrapped around the head, or was duct tape superimposed?
No, sir. It was wrapped around the face because it's a two-dimensional video.
But it showed it like that rather than wrapping.
Correct. And if I said that, I misspoke, Your Honor.
Okay. I just wanted to make sure that we were talking about the same video.
I think we are.
Okay. State.
The testimony from the expert witnesses in this case is that at some point that beautiful child did have duct tape over the area of her face, her nose, her mouth, one or both. I believe that the exhibit was necessary to establish the state's theory that this duct tape was sufficient to be the murder weapon, essentially, and was admissible for that purpose. I believe the doctor was very clear in indicating there were other possibilities. The video itself showed the duct tape moving above and below to clearly indicate that the position of the duct tape might not have been over both the nose and mouth. I believe it was a fair, though a very necessary demonstration for the jury in this case.
Anything else from the defense?
Nothing further, Your Honor.
Okay. When does the court have to rule on a motion for mistrial? Court can what? Reserve ruling on a motion for mistrial. Correct? Court can hold a ruling on a motion to mistrial, which was moved by the defense, up until the time before the court reads a verdict. Is that not correct?
I believe that's correct, sir.
And the verdict is not effective until after the court asks the verdict to be published. Correct?
I believe that is correct, sir.
So theoretically, the court could look at a verdict, rule on your motion for mistrial before announcing the verdict. Correct?
I believe you could.
Okay. Motion for mistrial at this time will be denied. I will take in consideration wherever future motions for mistrial, I will reserve ruling. But the motion for mistrial at this time will be denied. Okay, court will be in recess to 9 a.m. tomorrow morning.